Welcome, everyone. Thank you so much for joining us for today's Lunch and Learn, the Supreme Court case that upended federal Indian law. I first learned about this case, McGirt v. Oklahoma, from a 2019 podcast, and I have been deeply curious about it ever since. So I am absolutely thrilled to have Erick Giles with us here today. Erick is an attorney with DrummondWoodsum and a citizen of the Creek Nation, and he'll walk us through the case and its implications. Next slide. My name is Kathleen Neal. I am the Director of Policy and Partnerships at Maine Conservation Voters, Maine Conservation Alliance. Our organizations work to protect Maine's environment and our democracy by building diverse coalitions, influencing public policy, holding politicians accountable, and winning elections. Next slide. Oh, never mind. A few notes on the agenda and our technical notes for today. You're all muted, but we do want to hear from you. So you can send messages and questions to me, Kathleen, through the chat as they occur to you. You can find the chat by hovering your mouse over the bottom of the screen, and I will keep track of your questions to ask during the Q&A at the end. If you have any technical difficulties during the program, please message Will Sedlak through the chat. This event is being recorded, and we will share the video with you and post it on our website later this afternoon, where you can also find videos of all of our previous Lunch and Learns. Thanks again for joining us, and Erick, I will turn it over to you.
Thank you, Kathleen. So thank you everyone for attending and giving me the opportunity to speak to you about the McGirt versus Oklahoma case. Again, my name is Erick Giles. I'm an attorney here at DrummondWoodsum, and I'm a citizen of the Muscogee Creek Nation. And the McGirt versus Oklahoma case is it's a landmark decision. It was really significant in the field of federal Indian law, and primarily because it reaffirmed the jurisprudence about treaty rights regarding Native American tribes. And one myth I think should be dispelled right off the bat is that the Supreme Court did not transfer Eastern Oklahoma over to the 5 tribes, which is the Creek Nation, Cherokee Nation, Chickasaw Nation, Choctaw Nation, and Seminole Nation. What this was is the Supreme Court basically reaffirmed the 1866 Treaty of Creek Nation. And so I'll walk through a way to give you a better context and evaluating that. We should walk through kind of the history of Creek Nation and how it ended up there in Eastern Oklahoma. So on the first slide, what I show is the kind of the universal pattern that tribes in the United States all over have experienced. If you look on the right side of that, you'll see what tribes originally have is their Aboriginal territory, and then they come into contact with various European nations. And then once the United States becomes established, it entered into what is called the treaty era, the treaty-making era, and it entered into hundreds of treaties with tribes all over the country. And so what you see is that the boundaries and the land base of the tribes, they shrink. Sometimes just by contact, and then also through negotiated treaty. The part that is really has had the lasting legacy and one of the biggest impacts on American Indians today is when those reservations were then allotted, which basically was the Congress passed a law that subdivided reservations into individual parcels, and then those parcels were then allocated to individual Indians and heads of households. And then the remaining portions of those reservations were opened up to settlement, basically for white settlers, or in the case of Oklahoma, you had a lot of emancipated Black migration to Oklahoma from the South. So, and then in other cases, you might have where the tribe has agreed to a reservation, and then that reservation had to be opened up, and the tribe has agreed to another separate reservation in another location. So every tribe had some variation of that land tenure change throughout its history. So if we go to the next slide, and we can look at the land tenure pattern for the 5 civilized tribes. Here in this map, what you see is basically the snapshot of the tribes at the 1830 Indian Removal Act era. And prior to that, the area that the tribes would have been occupying would have incorporated all of North Carolina, South Carolina, Georgia, basically, and northern Florida, basically all the Southeast. And so when the United States gained its independence, one of the first programs it implemented was a civilization program for the 5 tribes. And so that's where the name 5 civilized tribes came from, is that you had the Creek Nation, Cherokee, Chickasaw, Choctaw, and Seminole undergo a civilization program. And that included the adoption of Christianity, slavery, plantation economics. The 5 tribes owned significant plantations that were worked through slave labor. And then that also, that type of civilization created fractions within the tribe itself, where you had more traditional entities, or what they called towns, preserving the traditional way of Creek culture, and then another faction that fully adopted these civilized programs. But one thing that is important to point out is that these introductions of Christianity, or legal principles, courts of law, all of those were adapted to Creek culture. So they were, the leadership at the time, they were taking the Bible and they were translating that into, in our language, Muscogee. They were creating written laws and written languages, all in Muscogee. So there was this push to civilize Indians in accordance with Western European ideals, but then they were all kind of adapted into Creek culture. And so there was, and that was applied to both the traditional factions as well as those factions that were more adoptive of those civilization programs. But they all still had they all maintained their Creek identity in that. So as history went on, what happened was Congress and the president at the time, Andrew Jackson, they passed what was called the Indian Removal Act, and that applied to the 5 tribes specifically. And what you see here are the treaties that the tribes entered into that removed the tribes from the Southeast and relocated them to what was then called Indian Territory, which was basically all lands west of the Mississippi River. And you can see where they ended up, which was what is today present-day Oklahoma, eastern Oklahoma. So if we go to the next slide, once they made it to eastern Oklahoma, they reconstituted their governments. They rebuilt their tribal court systems, their governments, their schools. Basically rebuilt their societies, and what happened though is as time went along, in 1856, the United States then entered into another treaty with the Creek Nation. And in 1856 treaty, which is really was critical in the McGirt decision, because what that did was it authorized, again, the tribe to create a court system, and it fixed their western boundary, as you can see here in the yellow. But probably this is what was critical in the McGirt decision. It stated expressly that no state or territory shall ever pass laws for the government of the Creek tribe of Indians, and no part of our land shall ever be embraced or annexed to any territory or state without the full and free consent of the legislative authority of the tribe. So that language is what really kind of carried the day in the McGirt decision. And as 1856 passed, and on the next slide you can see the boundary again for Creek Nation shrinks after the Civil War. The Civil War is a really important period for Creek Nation because the tribe, as I mentioned earlier, had split into factions prior to removal. And so when the Civil War came along, you again had the tribe split within itself. You had what were called the Lower Creek factions that aligned with the Confederacy, and then you had the northern factions that aligned with the Union. And so there were significant battles in eastern Oklahoma between these two armies that were fighting. And one of the biggest battles was the Battle of Honey Springs. But basically, what the lower Creeks wanted was to preserve slavery. And so after the Civil War, the United States then negotiated a new treaty. And in that treaty, it incorporated what is today the 13th Amendment of the Constitution. And in that treaty, you'll see the exact same language as the 13th Amendment, but it made emancipated slaves from the tribe members of the tribe. And so that today is a current issue still affecting the tribe, is the status of citizenship of the descendants of slaves of the Creek Nation. But what was important about that treaty is that it had that language about emancipated slaves, and it also, again, fixed the new boundaries of the reservation. But it did not affect anything in that 1856 treaty that talked about the tribe's consent to any state or territorial government being applied. So in the way of statutory construction, you have those prior treaties. The language in those treaties continue to carry over unless they are expressly abrogated or abolished by another treaty or law of Congress. And so this is really where this is the last treaty that the tribe had with the United States, and then that's what is what the current modern boundaries of the reservation are today. The next slide, go into that. Here, this map, this is where we have to talk about allotment. And as I mentioned, what allotment did is it subdivided the lands in the reservation. What the lands were prior to allotment is they were all held in common by the tribe itself. And so what allotment did was, the purpose of it was to assimilate Indians into becoming yeoman farmers. and it was a civilization, again, another attempt at civilization. And so what you see, the map on the right is the city of Tulsa. And so what you understand is that every single piece of land in modern day Tulsa can be traced back to an individual Creek Indian. And that all that land in there, that encompassed what are two traditional tribal towns of Creek Nation. One was Tulsa, Tulsi Town. The other is Logistical, which is where the turtle lives, and that's where my great-grandfather's tribal town is. So everything about Tulsa comes from Indian landowners. And you have to ask yourself, because when allotment was passed, it occurred in 1887, and it specifically applied to Creek Nation in 1898 under the Curtis Act. And then there was this agreement between the tribe and the United States in 1901 for allotment. And what you have to ask yourself is, like, how did all that land get to transfer out of Indian ownership into a modern non-Indian owners? And here I put in this link here to a 1924 report from these, they're called like the Friends of the Indian Societies, that really documented how BIA, Bureau of Indian Affairs agents, probate court judges, lawyers in Oklahoma all came together to collude to take individual Indian lands. And that included becoming guardians over minor Creek Indian girls, and doing, when an Indian person, Creek Indian, passed away, they would, once that person was dead, they take their thumb and put it on their thumbprint on a will, passing the land to some oil speculator, and then you would have judges, probate judges, who would be have their friends that were lawyers to basically just come up with all of these schemes to steal Indian land. And so that's really the origins of Tulsa and a lot of the modern day communities in eastern Oklahoma, how they came to be. Another issue that came out of allotment is fractionation, so that once those original allottees were assigned their lands, once that original owner passed away, he might have heirs, and then when his daughters and sons passed away, they had heirs, and so it just continued to this pattern of fractionation. So in some cases, you can actually have today a piece of land that's about maybe a couple acres, but you'll have like 50 fractionated interest holders in that one small piece of land, just based on the fractionation issue. And then in other places like on Pine Ridge in South Dakota, it's even worse. So that's what the legacy of allotment has resulted in. But what was really important with Creek Nation is that the mandate from Congress to what was called the Dawes Commission. The Dawes Commission was set up to negotiate allotment with Creek Nation, and their first priority was to get the tribe to cede the reservation to the Dawes Commission, and then open everything up to allotment. The tribe was adamant, and they refused any cession of the reservation. And so what the Dawes Commission came back to Congress and reported is like, they will not give up the reservation. And so but we're going to go ahead with allotment anyways. And that resistance to allotment was critical in the McGirt decision as well, because the tribe never consented to ceding the reservation. what you had was an agreement ultimately, because the Dawes Commission said, we are going to allot the reservation whether you agree to it or not. But the tribe would never agree to ceding the reservation. And so that distinction was really critical in McGirt. And so the once allotment went through, there was in 1901, the allotment agreement, and that was approved by Congress. And then a specific provision in that agreement said that we're going to allot the reservation, and by 1906, we are contemplating, we're going to say that the tribe will go out of existence, and there will be no further need to have a tribal government. And one of the actions that they did was to abolish our tribal court systems. They took away basically the power of the council to tax individual Indian lands. And so it was all this contemplation to get the tribe to go out of existence. But something that Congress did in 1906 is they passed the Five Tribes Act. And there the Congress says that the tribe shall continue to go on until further notice. And so the Congress made an affirmative act to continue to preserve the tribe's existence, even though the kind of the functions of the government itself were very limited. For instance, our principal chief was appointed by the president. He was no longer popularly elected by the membership, and they limited the amount of times that the council could meet and decide various pieces of legislation. So that was, and then 1 year later, in 1907, Oklahoma statehood passed, and Oklahoma came to be a state. And the first things that Oklahoma did was they started asserting jurisdiction over all Indians in all areas of the reservation. So, but it's really important to understand that that language in the 1856 treaty continued. The 1866 treaty was never abrogated by Congress. And then even though they allotted our reservation, there was still a legislation later on that preserved the government and said that it shall continue to go on. So in the next slide. So this is what where we are today, and this is what how Creek Nation exists today. Our headquarters are in Muscogee, Oklahoma. We're basically like any other municipality government. We have a principal chief, we have a council, and we were all basically reconstituted back in 1979 when the Bureau of Indian Affairs allowed us to draw up a new constitution and rebuild our tribal court systems. And so today we have a tribal court that asserts criminal and civil jurisdiction. And we have what is called the light horse police. Law enforcement operates several hospitals, sewer and water districts. We have building codes. We provide all those essential functions as any other government that you would expect from. And what has been a really kind of historic pattern of the tribe today is whether intergovernmental agreements between the tribe, counties, cities, and the state of Oklahoma. And so these compacts is what they're mostly referred to is, they control gaming, tobacco sales, motor vehicle fuel sales, and then the tribe itself actually issues its own license plates, and so it's a very modern day government that you see. But what also I think is kind of important is when I was out there, I went to school at the University of Oklahoma, and my mother, she was serving as the Attorney General for Creek Nation, and then she also served as Attorney General at Seminole Nation. But she was commuting back and forth from Washington D.C., and so I would pick her up, and we would drive, and be around Tulsa, and we would drive by certain places, and she would say, to me, well, that's where they stole Uncle Gus's property, and it was like every time, she would always, she would tell me that all the time, but it was like when she told me that, it would be like, to her, it was like the first time she would be telling me it. Or if we were carpooling with, some of the elders in the community, they would all point that out. They say, "Oh, there's where Uncle Gus's land was stolen." So that, that is, that trauma, I think, is just carried over through the generations. And people haven't forgotten that. So it's not like something that just kind of goes away. That allotment era and how it impacted, my mother's grandparents and what they all had to endure, is they grew up in poverty and they grew up poor, and so that lingers, to today, even though they've made we made all of this progress of reestablishing ourselves and rebuilding our institutions of governance. So what where we left off was basically that once the state of Oklahoma came into being in 1907, the first thing they really did was then to start taking control over all lands in eastern Oklahoma, including all of the reservation of Creek Nation. And so that pattern of asserting criminal and civil jurisdiction over the tribes continued for well over like 100 years. And then here in the McGirt case, what happened was I'll read you this, what my summary of the McGirt case is that, the Supreme Court, what they did was they held that the Creek Nation Reservation, as defined by the 1866 treaty, continues to exist as Indian country for purposes of the Federal Major Crimes Act. And the Major Crimes Act is a federal law that imposes federal criminal jurisdiction over state jurisdiction regarding certain major crimes where the offender and victim are Indians and the crime occurs within Indian country. So what the holding did was that it resolved a petition for a wrongful conviction in favor of Jim C. McGirt, who was convicted and sentenced to life in prison by an Oklahoma state court for a series of sexual assaults against a minor. Mr. McGirt argued that according to the Major Crimes Act, his crimes against a minor Indian should have been prosecuted in federal court and not state court because he's a Seminole Indian and the crimes occurred within Indian country on the Muscogee Creek Reservation. In the state of Oklahoma, what they ultimately argued was that Mr. McGirt's conviction should be upheld due to the state's historical practice of asserting state criminal jurisdiction over the reservation. And so what Justice Gorsuch called this is that he said, what Oklahoma really wants is they want to impose the rule of the strong over the rule of law. And that really what the threshold issue the Supreme Court had to resolve was whether the 1866 Muscogee Creek Reservation continues to exist despite all those numerous laws passed by Congress to assimilate Creek Indians and abolish the Creek government. While these federal laws, they paralyzed the Creek government and imposed a private property land tenure regime based on corruption and theft of Creek lands, they never expressly abrogated the 1866 treaty or abolished the reservation. And Justice Gorsuch, who wrote the majority opinion, he said, forced to leave their ancestral lands in Georgia and Alabama, the Creek Nation received assurances that their new lands in the West would be secure forever. Today, we are asked whether the land these treaties promise remains an Indian reservation for purposes of federal criminal law. Because Congress has not said otherwise, we hold the government to its word. And so what the McGirt decision really did was it just affirmed that fundamental principle of federal Indian law that if Congress wishes to break promises contained in a treaty, it must say so through express legislation. And so the boundaries of the reservation from 1866 have been upheld, they've been affirmed, and so today criminal jurisdiction is now under the federal government. It raised a lot of questions. Basically, how for number one is like the functional question is you had what Oklahoma was arguing was that the kind of a Chicken Little argument that the sky is going to fall, because you had they actually could never give you an accurate number or of how many convictions of Indians that they've prosecuted, and how many of those were actually in prison right now that could then apply for habeas corpus relief based on if they were wrongfully convicted in state court. They can never give you a solid number on that. And then also what does that mean for purposes of civil jurisdiction? And so there's civil jurisdiction is where you're regulating sales tax on restaurants, and or in Oklahoma's case, the biggest fear was that the tribe was going to start exercising civil jurisdiction over the oil and gas industry, which in Oklahoma has been documented very well that practices such as fracking have polluted the groundwater in certain areas. It has caused a number of earthquakes. So now Oklahoma is like this epicenter of earthquakes. Those were the biggest concerns, and that's what Oklahoma, in its argument to the Supreme Court, was really pushing, is that they wanted to say that, yeah, there's nothing affirmatively abolishing these treaties, and but who cares? Like, come on, we can't really allow a tribe to regulate non-Indians or have any kind of jurisdiction in this area, because Oklahoma's been doing this for so long. We just got to go along with it. But that's something what Justice Gorsuch said is that we reject that kind of thinking. We don't just say, oh well, let's just go along, because all of these, and what you might have seen in some of these hearings if you watched them for the recent Supreme Court nominee, is they all talk about this idea of originalism. And originalism is really looking at the law as written. And you apply the law as written. You don't, like what they all criticize as judge-made law. But here, in this case, there is nothing there that abolishes or abrogates the treaty, and there's actually legislation that affirms the existence of the tribe to go on. And so in the oral arguments in a related case to the McGirt was Murphy versus Royal, the lawyer in that case, when asked about the legislative authority of the Creek Council that continues to go on, her response was, well, so what? Who cares? We can't, this has been going on for over 100 years. Who cares if Congress didn't actually affirmatively terminate the tribe or abrogate the treaty? There's just not, we don't have to follow that. And so the dissent in this case, who are all of these originalist judges who pride themselves on applying the law as written, when it came to this case, they tossed all of that philosophy out, and they just said, we can't upset the settled expectations of Oklahoma. But here you had Justice Gorsuch's, you had these treaties that treaties are the supreme law of the land. You had another law passed by Congress affirmatively continuing the existence of the tribe. The tribe never consented to ceding its reservation under allotment, based on statutory construction, and there is no ambiguity whatsoever in any of these laws. Therefore, the reservation continues to exist, and so that I think is was the right outcome in this case. And the fallout so far has been that you've had the Seventh Circuit of Courts of Appeals in Oneida Tribe of Indians of Wisconsin versus Village of Hobart. The Seventh Circuit cited McGirt in upholding that the Oneida Reservation of Wisconsin continues to exist, was never abolished. More recent state court trial decisions in Oklahoma, they've upheld the Chickasaw Reservation and the Seminole Reservation. And that's why, it's really a landmark decision, because they applied all the principles that you would expect to see in statutory construction, and they upheld tribal rights in this case. So, that concludes my presentation, and I'm happy to answer any questions.
Thank you, Eric. Wow, this is a really hard story to hear, and I imagine a hard story to tell, and absolutely essential. So thank you for sharing it today. We have a bunch of questions, and we'll get to them in just a second. But our Lunch and Learn regulars know that this is the part of the program where we share a call to action. And this actually gets to one of the things that came up in the questions in the chat during your presentation, which is that though the case that you walked us through today, Eric, took place in Oklahoma, we know that the issues of tribal sovereignty and self-governance and the collective, harm done to Native people is not unique to that part of our country. And there are a lot of folks who are saying, well, how can we understand the history in Maine as well? And so I just want to share, we did do a little bit of exploration of that back in a Lunch and Learn in June. You can find the recording on our website, and really, really encourage folks to visit the WabanakieAlliance.com. Wabanaki Alliance is a new nonprofit organization that's emerged to really advocate for tribal sovereignty for the Wabanaki people. And Maine conservation voters were big supporters and proponents, and just encourage you to go and check it out and do some learning. Also, a reminder that it's really timely to think about, let's be thoughtful about who we put in positions of power and decision-making authority in this country. So we've got just a couple of weeks until the November 3rd election. I would love to just take a quick poll to see where we all are in developing our plans to vote. Maybe you've already voted in person. Maybe you dropped your absentee ballot in the mailbox. Maybe you have your PPE all laid out so that you can go down to the town office on November 3rd. What are you thinking? At this point, all plans are good plans as long as they get your vote cast and counted on election day. And while you're responding to that, I'll just share a little bit. Maine Conservation Alliance has been working to ensure that we all have the opportunity to vote safely in this election. And we've been working to make sure that folks who can vote absentee or early do that, to make sure that those who are going to vote in person on election day can do so safely and efficiently. So you can email abigail@maineconservation.org if you've got a fire lit under you today and want to get involved. And it looks like, wow, 71% of the folks on this call have already voted. Pat yourself on the back and dedicate yourself to getting other people into that category too. Thank you very much. And let's ask Erick some questions. All right. A couple logistical questions first. How big is the Muscogee Nation land area, and how many tribal members are there?
So we have about 90,000 tribal members. We have, the biggest community in East is around Okmulgee, eastern Oklahoma, and then there's a significant community in California around Riverside, and then there's just people like me that just live here by ourselves. But I would say that the total boundary of it would be maybe like 3 or 4 counties. It's not terribly big, but the reservation, that's the size of it that would encompass.
Okay, thank you. And so you talked a little bit about fractionation and the heirs property. How does that history show up in modern cases of land theft? Is that something that we see as a justification, or?
Well, so recently I guess under the Obama administration, there was a class action lawsuit on behalf of allottees. And since that era of allotment, in Oklahoma, you had huge oil and gas reserves. And so when there were oil and gas operations that were built on allotments, obviously the landowner is supposed to get a share of the royalties that come out of that. And in places like in the Northwest, you had timber harvesting, and in the Dakotas regions, they had a lot of agriculture leasing going on. But so it's those royalties that were supposed to be managed by a trustee, because the land itself, while it was allotted and assigned to the individual Indian, the title was still kept in trust by the United States. So those oil and gas royalties were supposed to go into a trust account managed by the Bureau of Indian Affairs. And starting from the date that individual Indian received an allotment, any royalties were supposed to go into what is called an individual Indian money trust account. And so what was shown was from like the period of 1900 to modern, to like 2010, the BIA could not account for all of those royalties. And so they actually couldn't come to an agreement, but what was shown was about close to like $10 billion was mismanaged or lost. And so you had, individual Indians that had all of these oil rigs pumping oil out of their lands, but they were poor and they grew up in poverty. And then where did all the money go? And no one knows. And so there was a big class action lawsuit on about 100,000 allottees. And there was ultimately a settlement for about $3 billion that went to the allottees. But then it also, a portion of that money went to dealing with this issue of fractionation. And it allocated blocks of money to tribes so that tribes could then go to that allotment and find those heirs, those fractionated interest heirs, and purchase those interests back. And so then it would consolidate those pieces of land. but it's still just really a short-term measure because you know, as you know, our elders pass on, you know, that fractionating issue keeps compounding. And it's important to know, though, too, in 1934, when they passed the Indian Reorganization Act, the head of the Bureau of Indian Affairs knew that this was going to be an issue. He said that, you know, 50, 60 years from now, you're going to see that there will be like 100 fractionated interest owners in these small pieces of land, and they will ultimately become useless for economic development purposes because you would have, if you were unless you had like a real, you know, profitable project, someone who wants to lease farmland is going to have to track down and get consent from basically like, you know, 100 people to say, you know, we agree to lease your land. And so it has been a really hindrance in places like Pine Ridge and Rosebud and those reservations in the South Dakota, because they can't lease out their lands for productive purposes. And so in some places you'll actually see where like on Lower Brule Sioux in South Dakota, the boundary of farmlands, productive farmlands, you know, just closely aligns with the boundaries of all the allotments, because no one wants to go into those areas and lease out those farmlands. Even though they might be really prime farmlands, people aren't going to, they choose to ignore those areas.
And so they just sit there, or what happens then?
I mean, they continue to just be idle lands. Wow. And you know, places like Crow Creek, Lower Brule, those are places that are, you know, really third world poverty areas of poverty that you would expect that you would not expect to see in the United States, but that's what the situation is now.
You know, I've heard McGirt described as a completely transformational ruling, but honestly, listening to this story and the history and the accumulated damage that has been done, it feels like just the very tiniest step toward what needs to be done. Well, what's the next step?
Well, I mean, I think what comes out of McGirt is you can't is that you know, courts of law, they're not going to be persuaded by the sky is falling if you rule in favor of the tribe. So you can imagine in some cases where, you know, the tribes, you know, is claiming that their reservation was never disestablished, and it encompasses, you know, portions that would have, you know, established towns and, you know, cities and stuff. And the response is, you know, we can't, you know, acknowledge that this reservation continues to exist because it's gonna, you know, upset, you know, the reason what was decided in prior cases by actually Ruth Bader Ginsburg. Is she said that, you know, we can't recognize reservations because it would disrupt the reasonable expectations of non-Indians living in these areas. That argument is no longer persuasive because of this McGirt decision. But that, you know, that is something that the dissent really wanted to uphold. And it was interesting because in McGirt, Ginsburg was actually in the majority, but everyone thought that she was going to be the deciding vote to cast against the tribe in that case because of her prior rulings on reasonable expectations. But because of McGirt now, you know, that argument is no longer, I think, persuasive anymore.
So does that, is it also more persuasive in the state legislative efforts, for example, in Maine with the tribal sovereignty?
Well,
questions?
yeah, and so you know, it's important to understand that Maine is the relationship with tribes in Maine is very distinct and different from tribes throughout the rest of the country. Here in Maine, you had the Settlement Act, and that Settlement Act, it goes beyond really what any Indian lawyer would think about, because it really puts the tribes in a position of being under state jurisdiction for really like almost all aspects of their their government, of how they manage their lands, and that's something that is very that doesn't happen anywhere else. And so when you look at that through the lens of a tribal sovereignty, you would have to say that doesn't that's not consistent with our understanding and principles of tribal sovereignty. And and how does that subvert treaty rights? Because the tribes in Maine had treaties, and so can you give away your treaty rights and your rights to self-governance to the state? And a lot of it just doesn't. There hasn't been any case that would show that. And so I don't know if you were to look at Maine, and if there was a court case in Maine, and the tribe was trying to reestablish or have its reservation boundaries recognized, I think if there was an argument that, well, you can't do that now because it's going to affect all of these towns along a river corridor or something like that. That should not, the court shouldn't be ruling based on that argument. In terms of a policy with renegotiating with the state of Maine and tribes, I don't see how you would say that things are great the way they are right now, because clearly the tribes in Maine are struggling, and if there was a better relationship that allowed for more expanded self-governance for the tribe on their own, you would see the benefits of that, I think. And in Oklahoma, really, it's a model for intergovernmental agreements and compacting. And I mean, I mentioned the Light Horse Police, law enforcement, and Creek Nation. They have cross deputization agreements with the state and local and municipalities. So so it's very you wouldn't even really notice it at all. If someone was to get arrested, they could be arrested by the Light Horse Police, but they would be taken to the processed in state and county jail systems. The only distinction that really matters now is whether or not someone who is being arrested is an Indian, and if that offender or if the person that they hurt was also an Indian. Then it would just be this, you would be taken to the tribal jail system and processed under tribal courts. It's not that like big of a shift, I guess. And then the benefits that the tribe provides, that they have these hospitals in the areas that are fully funded by tribal revenues, and they see tribal members, and they also see non-members. It's a very mutual relationship between the governments. And then people who live. This is another thing too. Is you're in the reservation now. You're a business. You're also eligible for all these economic benefits because you're providing economic development on a reservation. And there's a ton of like these empowerment zones and all these incentives that businesses get, like tax credits and all that kind of economic development benefits. And so I think I could see the same thing happening out here, is when you really kind of lift that restraint on the tribes. If they're able to exert their full self-governance powers, they could then really utilize all of those incentives out there that would help the state of Maine.
So what's in the queue? Are there other cases that we should be paying attention to, or are we watching for?
Well, more recently, the Penobscot Nation, they have a reservation boundary case that they just argued in the Second Circuit, and they're arguing is that their reservation encompasses not only the islands in the Penobscot River, but also the stems of the river, and including bank to bank. And so that's been a case that was argued recently by the lawyers here, DrummondWoodsum. But that's what's going on here in Maine, I think, right now. That's the one that really comes to mind. And you'll see, some other cases that will come up in Oklahoma, but also around the country, and regarding reservations, boundaries, and whether or not they've been disestablished, and they'll use McGirt as the starting point for their analysis. There's clearly some cases out there where the tribe agreed to cede the reservation. So that was an actual example was used in this McGirt case was with the Otoe, Missouri in Oklahoma. When they agreed to allotment, they had a specific provision in there that said the tribe agrees to allotting all of its lands in severalty, and the reservation shall no longer exist. So there's no ambiguity at all. And so this isn't going to be something where all the tribes, every tribe has to be evaluated on its own. Every tribe has its own unique relationship with the United States. It has its own history, and you can clearly see from my tribe's history, we're very different from what the Wabanaki tribe here in Maine have. We all have these different histories that we are going to be, if we want to bring claims, they all have to be evaluated on their own.
Well, Eric, it sounds like you've just signed up to come back and do a whole bunch more lunch and learns with us, because there's a lot for us to learn, and we are so grateful to you for walking us through McGirt today and helping us really deepen our understanding of our shared history. Thank you everyone for joining us today. We will email out a brief survey along with the recording of today's program later this afternoon. And if you've enjoyed our conversation today, I would encourage you to join our future Lunch and Learns every Friday from noon to 1. Next Friday, we have a couple of folks from the Nature-Based Education Consortium here in Maine who are going to help us explore how youth leadership and community collaborations are supporting nature-based initiatives in schools and communities. So very different topic, but should be another fascinating conversation. Thank you, Eric. Thank you to everyone.
One last point is, if you guys are interested in any more learning about the slavery history, the tribe, and the freedmen, what's called the freedmen issue now, that I'm working on now, feel free to reach out to me, and I'm happy to provide some additional information about that.
Thank you very much. We'll do that. Have a great weekend, everyone, and see you next week.
Take care.